Good morning to all of you. Welcome to my Jurisprudence class. So let us discuss question paper of 2018, question number 15. The brief facts of the problem are: the company is not paying wages properly and they are following the policy of hire and fire. So these 2 points are mainly important. So other points I cannot touch because I do not have the question paper. These 2 issues they have been noted in my notes. So I think you can understand that a company is there, it is following hire and fire policy, but even then it is not paying wages properly. So if they approach you, what you are going to do as an advocate? So please remember, since we are answering the topic on the subject of jurisprudence, so you have to think that this is a socio-political theory, socio-political concept. So socialistic school. Law should be doing the social welfare, right? So the issue is whether hire and fire policy can be followed in India, and can the management not pay the wages properly. So the first question can be answered in the positive way. Yes, hire and fire policy can be followed in India because an amendment has been made by the government of India. Hire and fire, this clause was introduced in the Employment within brackets Standing Order Act. Actually, this is a policy which is being followed in other countries. Hire and fire, plug and play. What is hire and fire policy? So hire and fire policies are those policies that allow a firm, maybe Accenture, maybe Amazon. We'll take up the Amazon case. So maybe Amazon. So they are the policies which allow them from to lay off workers whenever they deem so. They can lay off the workers. What is layoff? Suppose if there is no enough work, they can ask them to go away. So this is otherwise called as a retrenchment policy. Of course, in the previous videos, I have discussed in detail what is a strike, what is a strike, layoff, and what is the so-called retrenchment. So I need not reiterate the same. So yes, as per the so-called clause, definitely hire and fire policy is accepted in India also, because we are inviting so many multinational companies to come to India, and they operate with the policy of plug and play. That means the building, the infrastructure, everything will be available. They will just switch on, plug in. They play, they use their computers, they play all their games. Ultimately, if they are not happy, they plug out and go away. Even the employment is also like that. So hire and fire, that's all. They are not giving you employment on the regular basis. Suppose I was employed, I was appointed as a sub-inspector and retired as an additional SP. I worked for 35 years. So in the interregnum period, they cannot fire me out. But it is not policy here. It is only hire and fire policy. You will be hired. So that's why there is no relationship, there is no fiduciary relationship between the company and the employee. That's why they will be changing this present software generation. They will be changing companies as they like. Even the companies also, so fire them at that time. Nowadays, very recently heard, Google company, they have laid off 12,000 workers, and even Sundar Pichai, CEO of Google, he said because of the financial condition, we have to retrench them, we have to do the so-called layoff, right? Now, as regards paying of wages, first point I think it is clear. Hire and fire policy is accepted in India, but particular in relation to the industrial rules or labor rules, labor law. That's why India has already given an amendment, or it has found a clause, H&F clause. So definitely the companies in India, they can hire and fire the employees. Second point, but still not paying the wages properly. No, it is definitely A violation under the Payment of Wages Act 1936. So, Payment of Wages Act, definitely it regulates the payment of wages to certain class of persons like directly recruited or contract labor, that is indirect recruitment employees. So, definitely you have to pay the wages from the last week to the first week. That means payment of wages need not be done only on the first day of every month. It can be done earlier also in the last week, or it can be done within the first week also. But the only point is they have to give the salary in the current currency, coins and notes. So why I am telling this word particularly is because of the demonetization. Suppose if you have kept some 2 or 3 crores during the demonetization period, if you want to give that amount, nobody will take. That's why it should be in running or current coins and notes. Right? And as far as Payment of Wages Act also concerned, you will get a sheet. You will get your salary slip. It clearly indicates what is your total amount, what is your net salary, what is your gross salary, what are the cuttings, what is the HRA, what is the insurance, all these things will be there. So, please remember, it is a remedy against the unauthorized deductions also by the employer. And also, it is a remedy for the unjustified delay in the payment of wages. So therefore, Section 3 of the Payment of Wages Act says every employer is responsible for the payment of wages. If he fails, he is liable for punishment under Section 3 of the Payment of Wages Act. So I think now I have cleared both your one Hire&Fire accepted payment of wages should be done properly in time. Right? So in this connection, let us discuss a couple of case laws. The first case law is Mandegam Radhakrishna Reddy versus Sri Bharati Velu Bus Service and others, 1985. Bharati Velu. So when it was 1985, right? M. Radhakrishna Reddy actually is from Gudur area. He was working as a driver under Sri Bharati Velu Bus Service, and actually as a driver, normally he was involved in an accident where he also received some injuries, right? And a case was registered against him under Section 304 of the Indian Penal Code, and the case ended in acquittal, right? This incident took place in Gudur court in Andhra Pradesh only. Then he claimed after acquittal, he wanted to resume the job, and he claimed payment of wages for the period which he has since he was in attending the court. Actually they have terminated his services, so now he wanted to get the salaries, payback salaries under Section 15 of the Payment of Wages Act. But Bharati Velu, so that service people, bus service people, they said, no, since you are off duty, since you are involved in an accident, we removed you. How can we give back your salaries? Yes, since he came out successfully, since there is no allegation, the allegation against him is acquitted, yes, payment of wages, he has to be given. The court has stated that, yes, you have to pay the wages because in your service, he was involved in an accident. He was arrested. He was involved in a case. He attended the case. Now he has come out successful. You have to pay the wages. Very good judgment. Similarly, another Delhi Transport Corporation versus D.D. Gupta, 1984. Here, the driver was suspended for his misbehavior, directly to say. The driver was suspended for his misbehavior, and during the time he was paid only substance allowance. No doubt, definitely they have followed the principles just like CCA rules of the government employees also, right? But the suspension was held not to be correct. The labor court said the suspension is not correct. Therefore, he has to pay all the dues right from the date of suspension. So, under Section 15 of the Payment of Wages Act. So, these two cases, they stand proved as the employees have to be paid their due salaries also. Right? To conclude, I want to tell you, Hire&Fire policy can also be accepted basing on the H&F clause in India. but wages should be paid properly to the employees in the current currency. Okay, with this I am concluding. Thank you very much.